So I just welcome you to this webinar on the role of LGBT rights, on the situation and paths for recognizing LGBT rights in Latin America. And the cases that we'll be looking at today are Brazil, Colombia and Costa Rica in particular, but we'll also take a bit more of a regional view. My name is Siri Gloppen. I am the director of Law Transform, the UIB CMI Center on Law and Social Transformation, and a professor at the University of Bergen here in Norway. Law Transform is hosting this webinar jointly with Bergen Global. Before we start, I want you to all to note that the event is being recorded and will be published online afterwards. I would also like you all to know that you can ask questions throughout the whole event, and I will ask them to the panelists when it's time for the question session. I want to say a few words about Law Transform, the Center on Law and Social Transformation, before we start. The center aims to understand how rights and law are being used as tools and strategies for social change and to what effect, through research and through dialogues like this today. Law Transform is a collaboration between the Christian Michelsen Institute, a research institute in Bergen, and the University of Bergen in Norway, but it is a global center. It has research affiliates in the US, India, Latin America, Africa, Middle East, and Europe. And we collaborate on a range of research projects as well as teaching. We also have, which might be of interest for many of you who are joining today, we have a research unit particularly focused on gender and sexuality, where we have had different projects on LGBT rights and activism and struggles for LGBT rights in different parts of the world, and on political and legal determinants of sexual and reproductive rights and health. And I encourage you to check our webpage and follow us on Facebook and Instagram for information about research and upcoming events. For example, we have a new webinar in 2 weeks on abortion rights in Colombia that might be of interest to some of you. One of our projects is called Effects of Rights and Law. And this project is a collaboration between 7 different research institutions. And today we have scholars from 2 of the partner institutions in this project. And this is a project supported by DECO through the Interpart program of the Norwegian Research Council, and it aims to develop new research collaboration and new teaching collaboration between these institutions. And 2 of these institutions, as I said, are represented here. The first speaker today, Livia Busolin, is a PhD candidate in law and development at the Getulio Vargas Foundation in Sao Paulo, Brazil, which is one of our partners and very active partners in this project. She holds a master's degree from the same institution and a bachelor's degree in law and social communication. Livia is also an author of the book Direito Homoafetivo about LGBT rights in Brazil. And she will start by introducing the situation in Brazil with regard to the LGBT rights and the paths through which this have been recognized. But before she starts, I will introduce the 2 other speakers. Ana Cortes is a PhD candidate in public law at the University of Coimbra in Portugal and studies the recognition for LGBT persons in countries with a civil law system. She also holds a master's degree in law and development from the Getulio Vargas Foundation and a bachelor degree from the University of Sao Paulo. And she is currently in Bergen. She is a guest researcher at Law Transform, where she's also a research affiliate. And Anna is the organizer of this seminar. Last but not least is Bruce Wilson. Bruce is a professor of political science at the University of Central Florida. He is also a senior researcher at the Christian Michelsen Institute and a global fellow at Lord Friends Forum since the center started 6 years ago. And he has been involved in many projects, including projects on sexual and reproductive rights lawfare, global battles around sexual and reproductive rights, and a current project on water rights, the right to water as a human right, which he is leading. And his research on Latin American politics, on political economy, judicial politics, has been published in numerous peer-reviewed journals. So we're really happy to have all three of you with us today and look forward to a very interesting hour together. So the topic today is the battles that have taken place all over the Latin American continent for recognition of LGBT rights. And Brazil is one of the countries where the courts have been very central in this struggle. Can you, Livia, tell us a little bit about, start by introducing the situation in Brazil. What is it like? How did it happen?
Thank you. Good afternoon for those in Norway and Europe, and good morning for those in America. I'm very glad to be here today, and I would like to thank this opportunity that was given by the center, and to thank Ana Cortes for her amazing organization. Thanks Siri and Bruce for joining us in this webinar. And I would like to start by saying that I will first present which LGBT rights we have secured by now, and then I will talk a little bit about our judiciary branch and our legislative branch. So to give an image about the dynamics we have between those two branches that discuss LGBT rights here in Brazil. So like many Latin America countries, Brazil has a written constitution that has about 32 years old now, and that prescribe many social rights and rights to anti-discrimination. And this constitution also talks a little bit about our public administration. So we have Supreme Court, a federal Supreme Court that has 11 justices. And we also have a legislative branch that is bicameral, with a House of Representatives that has over 500 lawmakers, and a federal Senate that has over 80 Senate lawmakers. But despite all of these lawmakers that we have in Brazil, all the LGBT rights that were secured came by judicial decisions from the Federal Supreme Court. So now I will talk a little bit about these rights, and in chronological order. First, in May 2011, we had a Supreme Court decision ruling in favor of legalizing same-sex marriage. I'm saying marriage, but it's actually a common law marriage, or if I will translate literally, it will be a stable union. It's a kind of marriage. It also assures social security rights, inheritance rights, and filiation. And it was the first major decision for LGBT people here in Brazil in March 2011. And then 7 years later, we also, on the Federal Supreme Court, we had a decision ruling in favor for transgender people to adopt their social names in their records. And this allowed them to permanently change their gender marks and their first names on their birth certificates and official documents. And then in June 2019, last year, 2 years ago, we had the decision criminalizing homophobia and transphobia. since we don't have a specific law about this kind of conduct, the court decided that it will be applied our racism law, and homophobia and transphobia will be considered as a kind of racism here in Brazil. And in May 2020, we had also a federal Supreme Court ruling that gay men can donate blood, because first we had regulation by our sanitary agency stating that gay men could not donate blood. Okay, so each one of these cases, they have their own specificities that involves the way the litigation was strategically taken to the Supreme Court. It also involves how the civil society organizations presented their arguments, because we have arguments in favor and against the claims, and also the willingness for the Supreme Court to judge, to trial those cases in the past decade, because we have all these rights recognized from the past decade and all from our judiciary, but we still don't have any law about LGBT rights. So to understand a little bit about the dynamics, I will now talk about our judiciary branch. Our judiciary, our Supreme Court has a specific institutional design, which means that our justices, they all give individual opinions or votes on each case. So, and all the court sessions are broadcast by television, so the citizens can follow what's going on, what is being discussed. So in the case of the same-sex marriage, for example, the result of the judgment was unanimous, but when you look at the individual votes, you see that there was a divergence between in the reasoning and also in the legal concept that was being adopted, because a small numbers of justices don't understand that same-sex couples could be included in the legal concept of family that we have in our legal system, right? So we have this, you can see that there is this divergences. And another aspect that I like to highlight about our judiciary is that our justices don't have a very clear ideological point of view. So you cannot say for sure if one justice is liberal or conservative, which makes a little bit difficult for the social civil organizations to present their arguments to the justices, right? So, and when we look at our legislative branch, like I said, they don't have any law about LGBT rights in Brazil, but they have a lot of work doing in this subject, especially after the days that we have these Supreme Court decisions. There is a lot of movement by our lawmakers trying to reform those decisions and also trying to regulate those decisions. So I think one of, I have two hypotheses that should explain why we don't have any law about the subject. And the first one is that because Brazil, the Brazilian Congress has a very low rate of legislative success, which means that our lawmakers, they distribute, they make a lot of speeches on the tribune, they work a lot, but when the project comes from the lawmakers itself, it's not very easy to pass those laws. To give an image, it's about 2% of the bills that came from Congress that are approved. And other characteristics that we have in our legislative branch, it's that we have a huge evangelical bench that counts with 200 lawmakers, that it's about 1/3 of our lawmakers. And these religious lawmakers, they tend to be reactive to the movements that our judiciary makes to ensure those LGBT rights. So far, we have seen that this evangelical bench has not been capable to set the moral agenda of our Congress, because they have this opposition and their views is not moving forward. But for the past 5 years, Brazil has experienced increasing conservative wave in our Congress. And so this scenario may change for the next years. So if we look at, by now, we can say that there is a kind of paralysis in our legislative on LGBT rights, because there's not been any approval of legislative proposals. So to sum up, we can say that Brazil has made some progress in recognizing LGBT rights by assuring same-sex marriage, the adoption of the social name for transgender people, the criminalization of homophobia and transphobia, and also allowing gay men to donate blood. All these rights came from the judiciary. And when we look how this was done, we see that like many countries in Latin America, there was a result of strategic litigation on our Supreme Court. And the legislative branch still has not made a final decision about the subjects. And there are many proposals in favor of those decisions and also trying to reform those decisions. So while this paralysis is maintained in the Federal Congress, those decisions remain effective, and LGBT people can exercise these rights, right? But with this, the increasing conservative wave that we are experiencing now, it's necessary to remain alert and to follow these next movements. Thank you.
Thank you so much, Livia. This is an extremely interesting picture that you're drawing up, with quite a lot of progress in a context which is really difficult politically, but through using the courts. So, Anna, now I'm really interested in hearing more about the strategies that activists have been pursuing in this context. Anna Cortes.
So, hi everyone, good afternoon or good morning, depending on where you are in the world. And thank you, Siri, Livia, and Bruce for joining me here today. So, we are addressing here the recognition of rights for LGBT population in Latin America and focusing especially on the cases of Brazil, Costa Rica, and Colombia. These cases stand out for the relevant roles the courts played along these processes. Whereas Costa Rica and Colombia were each in its own way pioneers in recognizing LGBT rights and later experienced expressive anti-LGBT backlash, Brazil has been seeing in the last 10 years recognition of several rights with diverse nature that always came from decisions from the Federal Supreme Court and hardly ever from legislation, to not say never, I could say actually. And how rights are secured can be influenced by several factors, such as the international context, stances from international courts of human rights, the profiles and behavior of politicians, profile and behavior of courts, and civil society mobilization. And in the academic debate, the discussion divides into those who are skeptical about the possibility of courts bringing up social change, and those who can see the positive impact of courts' decision on social transformation. But from the mobilization actors' perspective, it's usually necessary to look for the most fruitful arena. There is to say, when organizations with limited human and financial resources mobilize in unfavorable conditions, they cannot dismiss available legal tools. So, for the Brazilian LGBT movement, the legislative way is not seen as a possible way to secure rights regarding especially some issues, so that organizations used to go to courts. This correlates with the fact that most of the recent achievements of Brazil's movement came from decisions from the Federal Supreme Court. The emphasis in the mobilization in courts is justified by some representatives of organizations with the fact that allies in Congress, even their allies in Congress, face a massive battle because of the conservative general profile the Congress has. This parliamentary way is not something they would focus their efforts on, though. It can be a strategy because there are several strategies in which they mobilize, but the focus where they would focus their efforts would be on courts in this case, seeing that the Federal Supreme Court has addressed even issues that polemize public opinion and Congress has not. And I say that from my contact and interviews with representatives from LGBT civil society organizations that mobilize Brazil's courts. The courts are not usually seen as the ideal and perfect arena, but as the possible way to battle for rights in this context. The possibility for civil society actors to mobilize courts depends on factors we call legal opportunity structure. And these structures comprehend, among other things, the possibilities of accessing the arena, the configuration of power, and the existence of allies and opponents. And a country's political configuration shapes the available opportunities for social movements. But at the same time, this movement can create political opportunities with their actions. Also, as long as victories are conquered and setbacks are faced in the legal sphere, either by the group itself or similar others, they can serve as inspiration or discouragement. When comparing the cases here, an essential factor to bear in mind is the access people have to the constitutional court in each country. I'm going to talk a little bit about Colombia and Costa Rica now, but Bruce can talk better about that, and even I learned that from him. So the Costa Rican Constitutional Chamber of the Supreme Court, commonly referred as Sala IV, receives claims from anyone in the country, regardless of age, gender, race, nationality, income level, or legal training. And in Colombia, cases can be filed under similar open access conditions with lower courts anywhere in the country, and the cases decided by these lower courts are automatically appealed to the Constitutional Court. In the Brazilian Federal Supreme Court, the situation is very different. And Livia has explained a little about the functioning of the Supreme Court, but I would like to say here that the court acts both as a specialized constitutional court for abstract judicial review and as a kind of an appeal court. In the cases when it works as what I'm calling here an appeal court, there are nowadays mechanisms that provide the court with the possibility to rule only the cases in which they recognize the social, political, or economic relevance, and also mechanisms to make the decisions binding. But anyway, most of the recognition of rights we address here, and Livia has talked about, came from decisions in which the court was acting as a centered and specialized constitutional court for abstract judicial review. These cases are binding for their own nature and attract much more media and popular attention. So while Colombian and Costa Rican constitutional courts have very few formalities and require no filing fees or lawyers to file a rights claim, the Brazilian ones present several challenges for accessing, such as requiring representation by lawyers, requiring expertise related to the court, requiring the right clothing and a specific vocabulary, and all of that besides the court having a quite unpredictable schedule. These challenges affect even tools that supposedly aim to democratize the arena, such as the amicus curiae and the public hearing. When it comes to taking a case to the Federal Supreme Court as abstract judicial review, the rules are even more strict, and it was until recently impossible for civil society organizations to do so. The first time this possibility was secured happened in 2018, when the Brazilian LGBT Association filed a complaint about the right for imprisoned transgender persons to stay allocated according to their gender identity. The challenges faced prevent many people from taking their claims to the Supreme Court, people and organizations, especially marginalized people and organizations with limited financial and human resources. But also, they stimulate articulation among these organizations and mobilization development. If the current opportunities in the political or the legal context can shape how social movement organizations act, on the other hand, these organizations also shape these scenarios. They can create opportunities and influence the political configuration. Social movements have the associative capacity and can unite and search for support in different ways. Social movements and the law can mutually influence each other. And the importance of social movement in the legal field is precisely establishing this link between law and society. And they can, like that, make law assume new meanings it never had before. So that's what I had to say for now. And I would like to hear from you, Siri and Bruce.
Thanks a lot, Anna. Thank you so much. This is really, really interesting. And I think one of the things that is, looking at this, for example, from a Norwegian perspective, one of the things that is really interesting is that the Colombian court can do what you called abstract review, which is that they can rule. They don't have to wait for a case or rule on a law or a provision in light of a case. They can rule on it in abstract, which means that they can then make it law if you want. They can change the meaning of the law. So this is of course opens up other possibilities that you're saying. Now we've learned a lot, and I've learned a lot on what has the situation in Brazil and what has been going on in Brazil. And now I'm very interested in hearing more from you, Bruce Wilson, about how does this in the context, in the broader Latin American context, and in light of the situation in Costa Rica and Colombia, where the courts have also been important. I see that you've shared the screen, but I don't think we can hear you.
There we go. Can you hear me now?
Yeah, we can hear you, but we have a very, we see a lot of things on your screen, so maybe.
Yes, I want to show this one, right? That's up. Can you just see one thing now?
No, we see your, sort of,
About that.
yeah, now it's, now we see it, but we can also see the next slide, so maybe you can even.
Well, it's not a big deal. Let's just leave it like this. So,
Okay, thank you.
my name is Bruce Wilson. I've been working in this area for some time. I want to thank Anna and Livia for excellent presentations. It was really, really interesting. And also to Anna for putting the whole thing together and for the technical staff at the back. So I just have a few slides here. It says 9, but it's not really. So if we look at sectoral orientation laws around the world, you see that Latin America, so the closer to blue or dark blue, the better. The closer to red, the worse. And you can see here that pretty much apart from Mongolia out there in Central Asia, Latin America looks pretty good. There's also areas of badness. I mean, there's Jamaica, where it's illegal to be engage in homosexual behavior, and you can see like most of the English-speaking Caribbean, the former British colonies, is similarly disposed, and Guyana. But by and large, it looks pretty good. But it's not always been like that. So because of civil law system, like the civil law that's largely used in Latin America, anti-gay law was not actually written, it wasn't written into law, it was by implication. So you could have laws about improper conduct or whatever, and that's what they would hold gays to court on, but not actual, generally speaking, anti-homosexual laws. But you can see here between like the 1999 and 2013 even, there's a huge shift, like the darker green, the better, the lighter green, and this is the big shift from one level of rights to the other. So big improvement across Latin America since 1999. And get the next slide. Here you can see sort of like gay marriage. This is almost like a pinnacle. And even this map, right, which is 2019, is incorrect now since Costa Rica also has same-sex marriage. But what's sort of interesting here is that so across the Americas, it's quite common. There are right now 8 countries in Latin America that have same-sex marriage either legalized nationally or in if it's a federal country like Mexico, in parts of the country. And this covers like 82% of the entire population of the Americas are now covered by same-sex marriage laws. And so in many ways, although this is not everybody's aspiration, and it wasn't even for many gay organizations and lesbian organizations back in the day, it does represent sort of like a peak right, the right to same-sex marriage, because once that law becomes effective and constitutionalized, it liberates and it animates a whole bunch of other laws that come into play, like property rights laws, etc. All these other rights that might be lower down the scale. The question is, so how do we get to this? I mean, this is in the last 2 decades, we've gone from 0 countries in Latin America to 8 countries that allow same-sex marriage. And how do we get there? And it's something of a puzzle. It's a bit of a conundrum. As you can see from this one, this is data from 2014, the end of 2014. Same-sex marriage is not exactly popular in Latin America, and yet it exists. And if you look at some of these countries like Ecuador, which legalized same-sex marriage last year, 16% support. Costa Rica, 29%, where it was legalized. Colombia, 28%. The only places where there's more than majority support for same-sex marriage is Argentina and Uruguay. And interestingly enough, both of those actually started as legislative initiatives and not as judicial ones. So this is sort of one of the conundrums here. And so I was given a talk in Costa Rica at the first Congress on same-sex marriage for the Americas. And there was a guy there who was part of the effort to legalize same-sex marriage in the United States. And he was convinced that the only way to have same-sex marriage is to have popular support for it. And what we've heard from Anna and from Olivia is that's not actually necessarily the case, right? Because there's other opportunities, there's other avenues that you could actually pursue rather than just go to a legislative assembly. And in fact, as Anna pointed out, maybe Olivia, that the Brazilian Congress is almost dysfunctional in its ability to pass laws. And many would argue the same is true for Costa Rica. But other places where they do effectively pass laws, like Uruguay, they actually can write laws about legalizing marijuana, same-sex marriage, abortion, etc. But anyway, this guy said that you really had to have popular support. So the strategy was not really to litigate. The strategy was to use social movements and to convince people that what was necessary was that gay people are as much the same as everybody else in the country. So you convince people that normalize the homosexual and lesbian goal of same-sex marriage. I don't think that's actually the case. And I think that litigation in the way that Anna described it, she does a very good job of describing both the Colombian and the Costa Rican case, is and has been in much of Latin America way more effective. If you think about Mexico, it started as a legislative issue in Mexico City back in the day, and then it was litigated state by state across the country because it's a federal system. Argentina, same thing, started in Argentina, in Buenos Aires province as a legislative issue, but then it was litigated at the national level. But in many of these cases, it's actually been litigated from the get-go, and this is true in Costa Rica. And one of the other things here is that it's not just about same-sex marriage, it is about all these other rights. And I think this is part of the question about backlash. Do we get backlash? Absolutely. And the backlash is often related to how much of an issue what is being claimed actually happens to be. So if it's something to do with, like, say, property rights, maybe a pension right, it's actually much easier to litigate under the radar without getting any kind of political backlash than if you would deal with something that touches on issues of family, broadly defined or defined by people who want to define it as such. If it's a family question, say like marriage, adoption, these are the sorts of things that have historically brought out significant backlashes. And it doesn't mean that you shouldn't litigate that. It just means that you need to be aware of what's may come next. And that's just part of a political process, I think. But the other thing about litigation is it's not all issues have to go to courts, like the proper court. I mean, in Brazil, it's like the local court and the federal court, and the same as in Colombia, where it gets appealed up to the National Constitutional Court. In Costa Rica, because it's a small country, the Constitutional Court behaves as a court of first appeal. You can take your case directly to that court, and people do exactly that. But there are also quasi-autonomous institutions that you can take your claim to. For example, hospital visitation rights, although ultimately was litigated in Costa Rica, the earliest successes came from actually lobbying the administrative bureaucracy that runs the health system. The changing of the names of transgender people on ID cards was originally taken to the Tribunal Supremo de las Elecciones. I mean, the people who control the registration of births, deaths, elections, and IDs, etc. So that is where you would take that. The other ones would be litigated, but you can also come up against blocks here. And this is where the sort of the comparison of Costa Rica and Colombia is quite instructive. In early years, Most countries were traditional, how would we put this politely, like machista countries where gay rights were not to be discussed and were not protected. And in the early years, like during the 1990s, it made huge progress, but up to a point, and then it sort of like plateaus. And then countries like Argentina and Brazil leapfrog over the top of them and end up legalizing same-sex marriage in a way that Colombia had not done. Colombia only did this a few years back, and ultimately by litigation. The Constitutional Court in Colombia differs from the progress that was done in Costa Rica. The Costa Rican court just said, no, you can't have same-sex marriage because that's not in the Constitution. Whereas the Colombian one says, well, there's a problem here you need to redress, and you have X number of months to fix this problem. So the Costa Rican one says, yeah, there is a problem. We recognize the problem. It's not a constitutional right, but there is a legal issue here about how do you treat same-sex couples legally. And they told the Congress to fix it, but gave them no deadline at all, which is pretty much to say, just do whatever you fancy, which is exactly what happened. So from that decision being made in 2006 until the last Congress was like 2020, nothing happened. It got bogged down for the same reasons that has been described here about in Brazil and stuff. But evangelicals and more conservative forces block it inside the Congress and make sure it can't get out of committee and into being voted on. Whereas the Colombian one, because they had this fixed date, said it has to be addressed and constitutionalized by this date, by legislation, or it becomes automatically constitutional. And that's sort of like it weighs at the end of the game, right? So there's a definite ending there. Congress either has to write a law that they like that regulates this, or the court has effectively done it for them. So in the Costa Rican case, which we now have, somebody, why is this not sure? There we go. We now actually have same-sex marriage being recognized. It was recognized last year, but it actually came as a result of the Inter-American Court for Human Rights decision on a constitutional question that Costa Rica itself had posed. The executive sent it to the Inter-American Court, which it is entitled to do, and the reason they sent it there was because the Costa Rican Constitutional Court would not deal with it, since they said they already had, and the Costa Rican Congress was not dealing with it. So by asking the Inter-American Court if Costa Rican law was conventional, like does it meet with the Inter-American Convention of Human Rights, then that's what they had to address. The court came back and said that it was not, and then Costa Rica has to address it. But the court doesn't say who in Costa Rica, just like Costa Rica, some body called Costa Rica has to fix this. The Costa Rican court then addressed it and says, okay, we have to comply with the Inter-American Court, but you now have 18 months to fix this to the Congress. 18 months, of course, went past and the Congress didn't fix it, so it became constitutional. This is also the piece of jurisprudence from the Inter-American Court that legalized same-sex marriage in Ecuador last year, where you saw earlier, it has 16% support, but Ecuador says, well, we have to follow what the Inter-American Court says, and so it became lawful. The reason I ask you if this is a help or a hindrance was that the Inter-American Court made this decision and released its jurisprudence 3 weeks before a national election in Costa Rica, which is what the photograph here is showing, is this celebration of people in, like lesbians and gays in Costa Rica after the court made the decision. And this is during the middle of this election that ultimately Carlos Alvarado won. But the danger is that because of the timing of the decision, the reaction in Costa Rica was to elect a slew of new evangelicals to the Congress that had never had representation before. So it is a very dangerous sort of thing to do. And apart from Ecuador, nobody else, and Costa Rica, no one else in Latin America has actually followed through on legalizing or constitutionalizing same-sex marriage. Okay, I'll stop it right there and we can deal with anything else in the questions.
Thanks a lot, Bruce, for sort of giving us the big canvas. Very, very interesting. A lot of questions in my head and probably in the audiences. So please write in the Q&A if you have, or chat if you have questions. And I already have, and I'm also going to let you ask questions to each other. But I'm going to start with one question that has been written in already from Ted Osterwal. And he asks, do you see any conceptual discrepancies between legal claims made on the basis of sexuality, contra gender in the context of Latin America, or are they in harmony? Obviously bearing in mind intersectionality, but it's been evident in other contexts that legal advancement of sexual minorities have often privileged a politics of liberal respectability or tolerance that is easily incorporated into existing frameworks, whereas trans and non-binary rights challenge these frameworks more. At least so it's argued. So a lot of aspects in this, but one of it was sort of the core of it is there a difference in maybe both mobilization and responsiveness to sexual orientation rights versus identity rights? I think I'll take one more that has come, and then you can think about both. The second one is from Anna Norede, and she asks, if the majority of the people in the country are against same-sex marriage, isn't it against the democratic ideal for Supreme Courts to go against the people's will? And of course, this is a core sort of conceptual issue that is being debated in this and many other fields. So who wants to go first? Maybe we go in the opposite direction. So you go first, Bruce. And then you need to open your microphone.
Yeah, sorry. So many buttons to push. So the first question, I think, is this. I'm not exactly sure how to answer you, but I can tell you that in some places, Bolivia, for example, have constitutional amendments protecting the rights of trans people, and also have a constitutional ban on same-sex marriage. So it's not always that direction. I'm not the best person to answer the more profound part of your question, which I apologize for. But the other question concerning whether Supreme Court should follow the majority view of the people, this is actually a very troubling. Not your idea is troubling, because the idea that courts should operate by majority will. In the US context, courts are meant to protect the minority from the tyranny of the majority. This is how they describe it. And what they mean by that is that just because somebody has animus towards you does not mean that your rights are any less respectable, any less worthy than if you are part of the dominant class. So and again, if you think about, say, Proposition 8 in California that bans same-sex marriage, the whole thing fell apart in the end because the court decided that what motivated the ban on same-sex marriage was not a question about law or a question about constitutionality. It was actually a question driven by animus. People dislike gay people. And because of that, they wanted to limit the rights or the enjoyability of life that gay people would have by having same-sex marriage. So I don't think it's the job of a court. Court should be looking at Constitution and the rights claimed, and then try to marry the two.
Thank you, Bruce. Anna and Livia, would you like to say something about, maybe to both, but particularly due to the first question on the mobilization in Brazil, particularly, of sexual orientation rights and trans rights?
Yes,
and also maybe about intersectionality, which is another interesting question that came up.
Yes, I thought of focusing my answer on mobilization because that was what I talked about. and the strategies vary a lot depending on which types of rights we are talking about, and also which framings we choose to take them to the legislative way or to the judicial way. And I worked with transgender rights specifically for my master's, and I had the opportunity to interview all the social movement organizations that mobilized the Federal Supreme Court, and it's a pacific thinking among them that it's not possible to take anything related to transgender rights to the legislative way, and it would not be a fruitful strategy. But there are bills, as Livia said, but nothing happens, that have been for a long time. But in other gender strategies, for example, women's rights, we have a lot of successful legislative strategies. For example, in not criminalizing, but making it a hate crime to kill women for gender reasons, and for protecting women from violence, domestic violence. And when we analyze the strategies in these cases, they vary a lot. And in the cases when they are in the Federal Supreme Court specifically, we see much more organized opponents in the cases related to sexuality than in the cases related to gender identity. About the other questions, I just have to agree with Bruce, and democracy should not be, we usually say that it should not be a majority dictatorships. And even in the law field, that I have to say, although I have a legal background, is usually much more strict. It's usually attributed to the courts the role to protect the rights of minorities.
Thank you, Anna. Before I give the word to you, Livia, I want to add a new question that came, and then the others can reflect on that. So, and it's Vegard Vibe who asks the question. And he says, first, thank you so much for the interesting presentations. Open court systems may also invite counter-litigation by conservative actors, as in the US and in the European system. Have you seen that with regard to LGBT rights in Latin America? Have you seen that in Brazil, Livia?
Yes, this happened more in the trial for criminalization for homophobia and transphobia. That was the first time that our evangelical bench came and asked to be a part of the lawsuit, and they were admitted as amicus curiae, and they contributed with a lot of arguments about freedom of religious and freedom of speech. And then these arguments were also faced by our justices on the ruling. So we have a lot of opposition also, because for the past years, they have been more organized and entering in arenas that is not, it wasn't so common for them. Because if you think that evangelical bench, their proper place was the legislative, but now they're coming to the judiciary to take their claims and to try to influence the justice in some ways. And we can see that in Brazil, and we can see that it's increasing, and we can see that it's getting more organized, and And first, for example, in the case of the same-sex marriage, the organizations that were against the recognitions were from the Catholic Church. And now we see a more of evangelical church trying to and taking those arguments to the court. So yes, we see this in Brazil also.
Thank you, Livia.
But not in the cases of transgender rights. That's really interesting because well, I don't know why, because they are against it indeed, and they mobilize a lot in other arenas, but they didn't file any manifestation as amicus curiae, for example, during the court cases. And in the cases regarding sexuality, they do it all the time, some horrible ones.
That is also really interesting. How is this in the rest of the region, Bruce?
So, I mean, that's a very good point, Vega. A couple of things though. So in the inter-American court system, it's not uncommon to have certainly amicus curiae coming in. You saw this with the in vitro fertilization case. You saw it with this particular case I mentioned about transgender and same-sex marriage rights. Because it becomes like, if you can get the inter-American court to say what you want them to say, then that like has effects on like 20-some signatory members. But the countries themselves, so it's not always that they would litigate. It's actually hard to litigate against somebody having a right. Right? Many of the rights that you see being litigated are people claiming access to rights that they're being denied, as opposed to, it's very difficult to make a claim that they shouldn't have that right. And that's the Prop 8 case in the US. But what you do see a rise of are the use of quasi-legal instruments, like writing up a referendum, for example, to write a new constitutional amendment to block same-sex marriage. That is not, I mean, this happened in Costa Rica. The Supreme Court said you can't do that because it was a limitation on people's rights. But you do see this with other types of rights where you start to argue, well, this right outweighs that right. And that's it's a much more difficult thing to deal with. Because, and so I'll give you one example. There was a case of a couple in Costa Rica who'd been kicked out a restaurant, and the restaurant owner said it's because they were being inappropriate, because the camera showed that all they were doing was sitting holding hands. So the case went to court, and the owner says, well, this is my property rights, it's my business rights, I can do what the hell I want in my business because it's my business, it's my constitutional right to earn a living. And one of the Congress people, one of the constitutional court members actually agreed with them, which I was horrified by. And what he actually goes on record saying is that the right to free enterprise outweighs the right to treat people equally in society. And I thought that was sort of interesting. But so there are 7 of them on the court. 1 out of 7 said this was the case. Now in the US, this has become very, very clear with the religious rights have now become, for want of a better term, a trump card that you can play against any other right. So if it's a gay right or this right or whatever the rights are, you bring out this thing and say, well, it's my firmly held religious conviction that this contradicts my belief. I shouldn't be forced to do that. And so that is the beginning of a new, I think, challenge. One last example would be, and again, it's not litigation, but it is in the case of in Colombia, where Constitutional Court had said that if Congress doesn't fix the law by a certain date, then all the people who have civil law marriages can convert those into regular marriages by going to a justice of the peace or a court in the local area. And the Attorney General, who I think is actually Opus Dei, had said, if any of you people do that, I'm going to have you disbarred. Right, so this is like then the state branch, I mean, the controlling branch of the judicial area, not inside the court, but the political appointee, was telling justices that they were not to uphold the law as had been determined by the court. I think this is it's a difficulty. It's this compliance question, and so these are parts of how people push back when they don't like this. But actually, litigating a case saying that they shouldn't get married is actually way more difficult, because you're basically saying that these rights shouldn't apply to those people because, and then you have to explain why. But there are other avenues that people can use to chip away at rights that exist.
Thank you. Thank you so much. Actually, our time is up, which it just went past so quickly. And that is due to 3 extremely knowledgeable and interesting panelists, and also very good questions from the audience. So I will just thank you for participating. Thanks to Livia. Thanks to Anna for organizing. Thanks to Bruce for informing us about so many things in the region. And to the audience for following us online. And please come back for other Law Transform seminars, and follow us on Facebook, Instagram, and our webpage. Thank you very much.